who held the first accused in high esteem as the political head of the county government of Migori, actually knew about it. For instance, PW28, who was a resident of Homa Bay, did not know about this relationship until Sharon herself told him about it. There is also evidence that even though claiming that his relationship with Sharon was already in the public domain, the first accused clearly wanted to contain it within the scope it had reached and prevent it from further spreading to contain it in the scope within which it was, because to illustrate this point, I would refer to the evidence of PW9 relating to what the first accused told him when he was leaving his Rapogi home after the meeting. And this is what PW9 claims that the first accused told him, and I quote, "The governor then escorted us outside the main house. We stood at the staircase. He bade us goodbye and promised to keep in touch after instructing me not to tell anybody about Sharon's pregnancy." This particular aspect of PW9's testimony was not expressly challenged by the first accused. Further, when under cross-examination by counsel for the victim's family, PW28, who the first accused admitted was a truthful witness, recalled having stated in his witness statement that when in a meeting with the second accused outside Tausi Hotel, the second accused had asked him how they could get access to the deceased and PW1's handsets, since they contained evidence that could take the governor to the media. The second accused was not involved in the information in the handsets, as reviewed by the evidence adduced in this case. And the concern he raised about this information getting to the media must have emanated from the first accused. From the above evidence and considering the exorbitant demands that the late Sharon had made to the first accused as a precondition to withholding her intention of going to the media with her story, I am persuaded to agree with the prosecution's submissions that the various amounts of money conveyed from the first accused to the deceased, either through PW28 or the second accused, were not genuinely intended to promote her well-being, but were designed to contain, to manage, and to delay, or to make Sharon abandon her intention to publicize her affair with the first accused as a scheme to eliminate her and to silence PW9 was being devised. The same argument applies to the first accused's promise to buy a plot and construct a 3-bedroomed house for Sharon in Homa Bay, since the promise was yet to be fulfilled by the time she met her untimely death. From the totality of the evidence adduced in this case, it is my considered view that the first accused had a very strong motive to unlawfully end Sharon's life, to ensure that his illicit affair with her was not widely publicized through the print media, in order to save himself from possible public embarrassment and reputational harm, and to safeguard his political standing. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot. No, sorry, let me go read this again. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot, as he was likely to suffer if the deceased actualized her threat of publishing them in the media, her story regarding their illicit love affair. In the premises, I am persuaded to agree. I'm persuaded to agree that in order to eradicate the imminent threat of having the possibility of having his name or reputation dragged through the mud by publication in the mainstream media of this relationship with Sharon, the first accused instigated a scheme to eliminate Sharon and using his influence as the governor of Migori County. He enlisted the services of his trusted aides, the second accused, who was his personal assistant, and the third accused, who worked as a clerical officer in the county government of Migori. This must be why, in my view, the first accused insisted to PW9 and to PW28 that all matters concerning Sharon's pregnancy should be directed to the second accused. And he consistently used the second accused as his intermediary with Sharon, PW9 and PW28. From the evidence, it is clear that the second accused embraced the role he had been assigned by the first accused. Because besides delivering money and other messages to Sharon, and sometimes to PW28 on behalf of the first accused, he also instructed PW9 and PW28 to keep off all matters related to Sharon, as he would henceforth deal with them. This finding is also strengthened by the evidence also adduced by the prosecution, which demonstrate or which shows that accused number 2 also embarked on activities meant to disguise or conceal his communication with Sharon, PW9 and PW22, as well as M-Pesa transactions. And this happened prior to the commission of the offense. This evidence is demonstrated by the evidence which was also admitted by the second accused, that on the 23rd of August 2018, he planned a visit to Nairobi by PW9, PW28, and Sharon, promising to schedule a meeting with the first accused. The first accused, as the evidence shows, was at the time attending a Council of Governors meeting in Nairobi. To facilitate the meeting, the second accused sent to PW9 22,000 to finance their travel with Sharon to Nairobi. But in doing so, he did not use his M-Pesa account. Instead, he chose to use the Safaricom line of PW4 to send the money, allegedly because he did not have his identity card at the time, which was required to effect the transaction. However, the reason given by the second accused for failure to use his M-Pesa account to make this transaction was disputed or refuted by PW4, who claimed that the reason given by the customer who requested her to use her M-Pesa line to send this money, who turned out to be the second accused, was because the customer claimed that he did not have a Safaricom line. This juxtaposed with the second accused's evidence that he actually had an active Safaricom line goes to prove that in using this using PW4's Safaricom line, the second accused was motivated by an intention of concealing his identity, which only means that he had a reason for wanting to have his identity concealed, so that this transaction would not be linked to him in the event that there were some investigations that concerned the transaction, or that concerned whatever schemes that were motivating this kind of dealing. I make this finding because I have no reason to doubt the evidence of PW4, because in my view, she was a completely independent witness, as she did not know the second accused, and she did not therefore have any reason to give false evidence against him. So it is therefore my finding that the only reason that the second accused would want to conceal his identity was to avoid being linked to the Nairobi visit, because it must have been planned for an illegal purpose. Another strand of circumstantial evidence adduced by the prosecution is that on the 27th of August 2018, the second accused acquired an Airtel line number 0739473321, which, in my view, was also aimed at disguising his communication with Sharon, PW1 and 28, and concealing his identity. according to the prosecution's evidence, which was not also disputed by the defense, this line was registered using an identity card earlier stolen from Vincent Abonyo, who testified as PW8. And after this line, and after acquiring this line, the second accused immediately disseminated it to PW9 and to PW28 with instructions that this is the only line they should henceforth use when communicating with him. In his defense, the second accused admitted having acquired this line, but denied having fraudulently registered it using a stolen identity card, claiming that he acquired it when it was already registered in PW8's name. He also admitted that he acquired this line for exclusive communication between him, the deceased, PW9 and PW8. But he continued using his regular Safaricom and Airtel lines to communicate with every other person. The second accused claim that he acquired this line when it was already registered in PW8's name cannot be true, because according to PW26, in order to acquire an Airtel line, the person seeking that acquisition had to register the SIM card using an identity card. PW26 also recalled that the person who registered their aforesaid line, who he could not remember, actually registered this line using an identity card issued in the name of Vincent Abonyo. PW26 evidence was not shaken in cross-examination by the second accused. And I am convinced that his evidence represented the factual position regarding how the second accused acquired that Airtel line. The fact that drawing from the foregoing, or drawing from that evidence, I am satisfied that the second accused fraudulently acquired the Airtel line for the sole objective of concealing his communication with the deceased, PW9 and PW28, so that any such communication would in future not be traced to him. His inconsistent explanations to PW9 and PW28 regarding the reason he had procured the line demonstrates lack of truthfulness and undermines the credibility of his testimony. More importantly, the fact that the line was fraudulently acquired just days before Sharon's murder, coupled with the second accused's insistence that the line be used as the exclusive channel of communication between Sharon, PW9, and PW28, the only two people who had become Sharon's close associates, leads me to an irresistible inference that this line was acquired as part of acts of preparation for commission of the offense. Regarding the events of that September 2018, which needless to state is the date that Sharon was abducted and subsequently killed, the prosecution led evidence seeking to prove that there was a preparatory meeting held at the third accused's wife's home, that is Olivia's home, in the morning. PW38 testified that he found the third accused seated outside the home in an apparent meeting with one Dicky. Olivia and Elvis were inside the house. PW38 had gone to the house to pick a copy of the subject vehicle's logbook to facilitate its valuation. In his evidence at a cross-examination, PW38 clarified that he had confused the time that he had gone to the home, that it must have been after 12 or 3 p.m. since he went to the home after talking to Olivia. The second and third accused denied having attended any such meeting, claiming that they did not leave their places of work on that day. At a cross-examination, however, the third accused recalled that in his statement to the police, he had actually admitted that he was at Olivia's home on that day around midday. Although the second accused claimed that on that day he was busy in his office preparing for an official trip to Rwanda on the following day, the email correspondence from the travel agent, which he produced as a defense exhibit 4, indicated that as late as 12:59 p.m., his ticket to Rwanda had not been confirmed, as it was still on the waiting list. Elvis, who testified as defense witness 4, also denied having been present at Olivia's home at the time alleged. I must state that in my assessment, I found Elvis struck me as an untruthful witness, considering that he claimed in his evidence that he did not know Sharon or her relationship with the first accused, despite the fact that there was evidence which he admitted that he had been one of the first accused's bodyguards and had worked in that capacity for 10 years. In the circumstances, he's claimed that he was not aware of that relationship was implausible and can only mean that he cannot be taken to have been a credible witness. I therefore do not give any weight to his claim, to his evidence. Continuing with evidence adduced relating to the events of that September 2018, the prosecution also tendered evidence through the evidence of PW9 and PW13 not 13, PW 38, to prove that the second accused convened a meeting with Sharon and PW 9 at Gracia Hotel in the evening. This meeting, as noted earlier, was acknowledged by the second accused in his evidence, and he admitted having met Sharon and PW9 in that hotel to deliver a message from the first accused. There is also evidence which was also admitted by the second accused that he left this hotel together with Sharon and PW9, and although there was conflicting evidence between the evidence given by PW9 and PW38 regarding the manner in which these two witnesses, Sharon and PW9, together with the second accused, left the hotel. There is evidence that PW9 and Sharon boarded the vehicle that was being driven by PW38. Whereas there is, according to PW9, the second accused also boarded the same vehicle. There is evidence that this is the vehicle in which the second accused, Sharon and PW9 were allegedly kidnapped, and the vehicle that and it is this vehicle that transported the late Sharon to the scene in which she was subsequently killed. I have noted the discrepancy between PW9's and PW38's evidence regarding whether or not the second accused boarded the subject motor vehicle. In my mind, while the accounts of PW9 and PW38 differ on the precise sequence of how they left the scene, they converge on the critical point that on the 3rd of September 2018, the second accused was with the deceased in PW9 at Gracia Hotel in the company of unidentified men, and the final point of separation was either at the hotel gate or the roadside near the petrol station. Whether the second accused boarded the vehicle at the hotel or joined them later is immaterial. Both witnesses confirm that he was present and was involved at the precise moment. And although the second accused in his defense denied knowledge of or any association with the unidentified men, he did not challenge the evidence of PW9 and PW38 about the presence of these unidentified men or his association with them. It is important to mention that in their written submissions, learned counsel for each of the accused persons submitted at length on their foregoing contradictions and strongly attacked the credibility of PW9 and PW38, asserting that the evidence was planted and was fabricated. The attack on PW9's credibility was mainly two-pronged. First, it was admitted that he was not a truthful witness because he had earlier described the motor vehicle used in his and Sharon's abduction as black. The test used by courts to determine the impact of contradictions or inconsistencies on the prosecution's case is a substantive one. It requires the court to inquire whether the contradictions or consistencies were so material to the issues in question that they would deal a fatal blow to the prosecution case. In the case of Eric Onyango Odeng versus Republic, the Court of Appeal held that minor discrepancies and inconsistencies in the evidence of prosecution witnesses were natural and inevitable, where different witnesses recounted the same events from different perspectives. Such inconsistencies would not render the prosecution's case unreliable unless they were material and go to the root of the charge, or that they created reasonable doubt as to the guilt of the accused, or demonstrated deliberate falsehood. The Court of Appeal guided that only grave and unexplained contradictions that affect the substance of the prosecution's case may justify rejecting the evidence. I have keenly considered the contradictions which the defense has made very heavy weather of during cross-examination and in their submissions. I find that the contradictions in the evidence of PW9 and PW38 mainly related to whether the second accused boarded the vehicle at the hotel, whether the vehicle had music, and whether the late Sharon expressed distress when the vehicle was on transit. In my opinion, these contradictions related to peripheral matters that did not go to the root of the prosecution case. With respect to the contradictions in PW9's evidence, PW9 explained that he had described the subject vehicle as dark stroke black because he had seen it at night in circumstances that did not allow to see its color properly. This explanation in my view is reasonable and does not this explanation is in my view reasonable and does not indicate or is not evidence of any dishonesty or untruthfulness in the evidence of PW9, because even considering ordinary circumstances, color gray fits the description of dark. Considering that even in ordinary circumstances, color gray fits the description of a dark as opposed to a bright color like white, cream, yellow, orange, or whatever other bright color you can think about, and may look like black whenever viewed in the darkness. In any event, it is common knowledge that a vehicle is identified through its registration number and not through its color. In my considered view, the contradictions in PW9 and PW38's evidence were not fundamental to the key issues in question in this case, and we are thus not fatal to the prosecution case. Regarding the challenge on PW9's and PW38's credibility, contrary to the defense's submissions, I find nothing on record that would cast aspersions on the credibility of these witnesses. I watched the witnesses as they testified, and in my view, they gave clear, detailed, and consistent eyewitness accounts of the events that took place on that September 2018. PW38 explained that the few contradictions in the various statements he recorded with the police were as a result of the structured approach used by the investigating officers, which restricted him to answering only questions put to him. And these contradictions in that context cannot be viewed as indicative of untruthfulness on the part of PW38. With respect to PW9's evidence, his claim that he escaped from the subject vehicle when it was in motion was materially corroborated by PW27, in whose home he sought refuge. PW6, who recorded his abduction report at Kadeo Police Post, and PW9, who treated him for his injuries. PW27's evidence regarding how PW9 stormed into his house out of breath, visibly shaken and in a panic, and the fact that the first instinct of PW9 was to hide under a bed is quite telling. In addition, the description by PW6 and PW10, PW6 was the police officer who recorded his PW9's report at Kadeo Police Post. PW10 was the clinical officer who treated him. And the fact that these two witnesses confirmed in their evidence that when they saw PW9, he was visibly shaking to an extent that he was trembling when he was recording his statement or when he was being treated. These accounts by these two witnesses reinforced PW9's claim that he had just escaped from a life-threatening situation. Additionally, in the course of the trial, PW9 demonstrated to the court how he had managed to jump out from the moving vehicle, which according to PW38 had been moving at a speed of 60 kilometers per hour approximately, and not 80 kilometers per hour as alleged by the defense. Further, PW4's attempt to discredit PW9's evidence on this point dismally failed, because since he admitted that his expertise was only limited to motor vehicle assessments, he was not an expert on the law of motion in his own admission, and that he was not in his admission. He was only his only expertise related to motor vehicle assessments, and he was not therefore an expert on the law of motion and assessment of impacts that would be expected of a person or an object falling. That the first accused although physically absent, must have been aware at the meeting at Gracia Hotel. Since in the second accused admission, he's the one who had sent him to deliver money to Sharon in that hotel. It is also apparent that according to PW9 and PW38, the conversations that these unidentified men had with the late Sharon and PW9 led the conversations that these unidentified men had with the late Sharon and PW9, according to PW9 and PW38, who I have already found were credible witnesses, gave an inference that these unidentified men had some linkage to the first accused and appeared intent on protecting him, considering that they questioned Sharon and PW9 regarding their relationship with the first accused and why PW9 was following a story about the first accused. Turning now to the alleged involvement of PW9 in the evidence adduced by the prosecution, seeking to prove or seeking to establish the third accused. Turning now to the evidence adduced by the prosecution, seeking to establish the third accused's alleged involvement in having a scheme to unlawfully kill Sharon, I find that in his defense, the third accused denied having played any role in Sharon's death. And as noted earlier, he emphasized that he did not have any reason to be involved in her death because he even barely knew her. But he admitted having accompanied the second accused to meetings in which the late Sharon was involved twice. The first meeting was in a hotel at Homa Bay, when the second accused was delivering money to Sharon on behalf of the first accused, and the second one was at Capital Center during the Nairobi visit. The prosecution also linked the third accused to the commission of this offense because by the fact that the vehicle used in the abduction and eventual transportation of Sharon to the place in which she met her death was owned by Olivia, who was his second wife. PW39 confirmed in her evidence that the third accused's wife had been given access to the tracking device in the subject motor vehicle through a letter she produced in evidence as prosecution exhibit 53C, and that between 3rd September 2018 and the morning of the 4th September, the tracking device was not working. And indicating that it was either tampered with or disabled by failing to load its SIM card with airtime. It must be remembered that the 3rd September is the day that the late Sharon was killed. The fact that the tracking device failed at the very time that the vehicle in which Sharon was abducted was being used for the commission of an offense, for the commission of the offense, cannot be a case of mere coincidence. The two explanations given by PW9 regarding why the tracking device would cease functioning involved deliberate human intervention. Which means that the disablement of this tracking device was not a matter of a technological failure or something to that effect. Interference with this device on the day that Sharon was abducted and later killed is a strong basis upon which a strong inference can be made with regard to the preparation and concealment of the purpose for which this device was made unfunctionable. It demonstrated planning and intention to avoid detection. The prosecution also adduced evidence to prove that on the 4th September 2018, a day after the offense was committed, the third accused introduced the second accused to PW22, requesting him to procure fake medical records, which were generated by PW20 on the request by PW22. It is apparent from the above fabricated medical reports that they were meant to support a report made at Oriri Police Station to PW3 on the same day by the second accused, claiming that he had been abducted by unknown people on the previous evening, in the course of which he had been beaten and robbed. Investigations revealed that this report by the second accused was a false report. And this is what meant to his arrest at Oriri Police Station. And though both the second and third accused persons denied having ever requested PW22 for procurement of these false medical reports, they failed to explain how the said documents bore the second accused's name and personal details. Importantly, the second accused did not disown those details. The submissions made on behalf of the two accused persons, impugning PW22's evidence on grounds that he had handed over the documents to the second accused at around midday, when the second accused was already at Oriri Police Station, are, in my view, with a lot of respect, misplaced. they appear to be based on a misapprehension of PW22's evidence. PW22 clearly stated in his evidence that he handed over the fake medical records to the third accused on instructions by the second accused. He did not say in his evidence that he had handed over the documents to the second accused. In my view, the denial by the second and third accused that the denial by the second and third accused of involvement in the procurement of the forged medical records amounted to mere denials or afterthoughts, which did not affect the veracity of the two prosecution witnesses. These witnesses were independent witnesses in this case, and no reason was given by either the first or second accused that they had any reason to fabricate or give false evidence against them, against the two accused persons. That said, I agree with the second accused that PW 42's claim, that is the investigating officer's claim, that that the second accused is the person who presented the false medical report or the false medical records to Oriri police station when making his abduction report, and that the investigating officer collected the medical reports from Oriri police station in the course of his investigations cannot be true. This claim by PW 42 was not supported by the rest of the evidence on record. There is evidence from the arresting officers at Oriri police station that at the time the accused was arrested, he was searched and nothing in the nature of documents were found in his possession. The other reason that I have made a finding that PW 42's evidence on that aspect was untrue is because that claim that he had collected these false medical reports at Oriri police station where they had been taken to the accused person flies in the face of the letter dated 13th June 2022 produced by the second accused as defense exhibit 4, in which the investigating team was giving the second accused a notice through his advocates to produce original copies of the same documents. Having totally and thoroughly evaluated the evidence presented by the prosecution in support of his claim that the third accused jointly with the other accused persons or other persons not before the court execute in common with having thoroughly examined the prosecution's case, seeking to prove that the third accused planned in conjunction with the accused persons and in execution of their common intention to cause the death of the second to cause the death of Sharon. and having juxtaposed that evidence or compared that evidence with the evidence adduced by the third accused, I have come to the conclusion that the third accused was not a passive bystander, but was an active participant in the events that resulted in Sharon's death. His conduct of assisting the second accused to invent a false alibi to cover his tracks on the night Sharon was unlawfully killed is incompatible with his innocence. It is also noteworthy that although the third accused testified that he did not report directly to the first accused in the course of his duties, the data records produced by PW40 in respect of the first accused's mobile number, that is 0722469587, shows that in the 2 days between 2nd and 3rd September 2018, the first accused made a total of 5 calls to the third accused. The call data records produced as XB64 show that the first accused made the first 2 calls on 2nd September 2018, and the other 3 calls were made on 3rd September 2018. The third accused call to the first accused was made on the following day, that is on 4th September at 7:31 p.m. The number of these calls per day and on days that were either just before or on the day that the offense was committed, and on the day subsequent to commission of the offense, give a reasonable inference that these calls were made for purposes that were connected to the offense that was committed on the 3rd of September 2018. Or for purposes that were in furtherance of ensuring that there was planning and coordination of the events that led to the commission of the offense on that date. I make that finding based on the timing and the frequency of those calls, and also because the content of those calls were matters that were within the special knowledge of both the first and the third accused persons. And under section 111 subsection 1 of the Evidence Act, the burden of proof shifted to the accused persons to explain the reasons that these calls were made, in the manner in which they were made, and in order to rebut the presumption that the calls had been made for an illegal purpose. The first and the third accused failed to discharge that burden. Having carefully appraised the evidence on record in its entirety, it is clear to me that the evidence demonstrated, it is clear that the evidence adduced by the prosecution in this case demonstrated and left no doubt that the accused persons acted in concert, jointly with others not before the court, pursuant to a common design, each performing a distinct role in furtherance of a criminal enterprise that resulted in the death of the late Sharon. To summarize, the first accused supplied motive, instigation, and funds to finance the criminal enterprise. The second accused facilitated execution, where the third accused ensured logistical support and concealment to avoid detection of the offense. Inherent in these roles were acts of preparation and concealment, denoting knowledge, participation, premeditation, and intention to execute their common intention aimed at executing their common intention that ultimately led to the death of Sharon. These acts constituted malice aforethought as defined in Section 206 of the Penal Code. The fact that the first accused, alibi that he was not in Migori County at the time the offense was committed, and the same was vindicated by the evidence that was produced in this case, and that he was in Nairobi from the 2nd of September all through, even from he was in Nairobi from the 2nd of September and was not therefore physically in Migori when the offense was committed. That's not, meaning that he was not physically present in the place where this offense was committed, does not shield him from criminal culpability, since under the doctrine of common intention, criminal liability does not depend on who physically commits the actus reus, but whether the accused acted in concert with others to execute an unlawful purpose. Applying the legal principles governing the application of circumstantial evidence to the present case, and having in mind the law regarding the definition of principal offenders as stipulated in Section 20 of the Penal Code, I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to Section 203 of the Penal Code, as charged in Count 1. Each accused is accordingly convicted under Section 322 of the Criminal Procedure Code.
Most of it. May I request that you guide us into the next phase of this trial?
Okay. Whether they are ready to take directions on the sentence hearing, and whether the councils representing the state are also ready with the information regarding whether or not the first accused person, the accused persons have any previous convictions or not, so that we are able to give directions on the way forward.
Yes, Melody. Apologies, I was late. I had a meeting that I had to attend. In regards to directions, we are ready to take directions on sentencing hearing. We would also like to be given time to get the reports on any previous sentences, so we can supply the same to the courts.
Just a minute.
We'll also be requesting the courts.
Okay. So start again, Ms. Kikwe.
Melody, I said that as for the Republic, we are ready to take directions on this matter. We do not have the previous convictions reported on this person.
You are very fast.
Oh, sorry, I apologize.
You're saying you started by saying that you apologized for coming late.
Yes, Melody, I apologize for coming late. I had a meeting which I'd been directed to attend. But I had a team of 3 prosecutors who are here. In terms of directions, Melody, we are ready to take directions on sentencing. we'd also like time to provide, to request and provide to the court reports on previous convictions for the accused persons.
You would also like time?
Time,
Mhm.
so that we can request from the DCI reports on any previous convictions of the accused persons. So we can supply the same to this court. The lady would also be requesting the court to order for pre-sentence reports from the probation department. And for the same to be supplied before the next sentencing hearing date. That will grant us. My lady, finally, in regards to the judgment you have given, we'll be requesting for the 3 accused persons' bail bonds be cancelled and for them to be remanded in custody. That's all, my lady.
Mr. Awar?
Thank you, my lady. I support the applications made by the state. So the fact that to emphasize that we request for specific order for the preparation and supply of victims.
Same to emphasize that?
We request for specific order to the probation officers to prepare and supply us with victim impact statements. Prior to the date that will be set.
That the probation officers prepare?
Prepare
Mhm.
and supply us with victim impact statements under the Victim Protection Act, Section 12. The same be done prior to the date that the court will set for sentencing.
So this
Thank you.
Counsel for first accused.
Your Ladyship, I wish to address you on the request for cancellation of bail. That's the only issue I wish to address you on. Your Ladyship, the preparation of the reports from probation officers, including the victim impact report.
The preparation of the report.
Probation, yeah, resentencing reports, which the prosecution has requested, and the victim impact assessment reports. The preparation of those reports takes time. And so the date for sentencing is likely to take into account the period that will be taken in the preparation of those reports. Your Ladyship, the request by the prosecution to cancel the bail to which the accused persons were admitted to is not an unusual request. People are admitted to bail on account of presumption to innocence, which has now fallen off.
Okay.
However, Your Ladyship has judicial discretion.
Just a minute, Counsel, so that I do not lose you. You are saying that the preparation of these reports
Will take time. Yes.
Mhm.
In fact, most likely more than 30 days from experience will be taken in preparation of these reports. And I am saying the request made by the prosecution is reasonable, because people are admitted to bail on the premises that they are presumed innocent. That presumption has fallen off.
Slowly, Counsel.
Yes, sorry.
Yes, go ahead.
So, Your Ladyship, I was saying, with the guilty verdict that you've rendered today, that presumption falls off. However, the court still has discretion to extend the bail terms up to the date of sentence. Your Honor, in respect of the first accused, he was released on bail on the 24th of October, 2018.
On 20?
On 2018, on 24th of October, 2018. That's when he was released on bail. And Your Ladyship, for the last 8 years, he has dutifully attended court whenever required. his passport, including his diplomatic passport, is deposited with the court. I ask your ladyship, in view of these circumstances, to consider extending the bail terms to the date of sentencing. That is all, your ladyship.
Okay, counsel for second accused.
Thank you, my lady. Lady, on behalf of the second accused, we are grateful for the judgment you have rendered. And we take cognizance of the submissions by my learned colleague, the prosecutor. Same as to my lady, since when the second accused was admitted on bail, he has religiously attended court. And even on the single instance when he did attend, he provided an explanation, which the court didn't give a finding of doubt on the same.
Since the second accused was admitted to bond,
He has been religiously attending court, my lady. And on the single instance, he didn't attend because of the reason for illness. Evidence of the same was tendered before court, my lady. And to associate myself with the submissions of Madam Senior Counsel Kikumi, this court has discretion to extend bail until the date of sentencing, my lady. Which we hereby humbly ask the court to consider. That the accused be allowed to continue enjoying bail until when this court shall render sentencing. And again, we agree with my learned senior, my lady, that the sentencing report may take a while. We humbly pray, my lady, that's all.
counsel for third.
My lady, on behalf of the third accused, I also thank you for the judgment. My lady, to avoid rehashing what my colleagues for the first and second accused persons have said, first, we are ready to take directions as to the sentencing. And in relation to the application for revocation of bond and bail bonds, on behalf of the third accused, we also pray very humbly that you be pleased to extend the bond terms of the third accused person. My lady, I will adopt mutatis mutandis, the reasons afforded by the learned senior and my colleague, Mr. Obado. And just as a confirmation, my lady, the third accused person has also religiously attended for the last 8 years. And we'll pray, my lady, that you'll be pleased to exercise that discretion in his favor. Lastly, my lady, in the intervening period, my lady, we will pray that, and I believe I've seen my lady with a printed copy of the judgment. We will pray that if the same is ready, we will be supplied with a copy of the judgment in the intervening period. Even as we wait for the sentencing hearing. That is all.
So, Ms. Kikoy, I don't know whether you have any response before I give.
The practice has always been for billboards to be cancelled once a judgment for guilty has been provided. So that aspect will lead to the court.
Okay, so I do not know what is the practice in Nairobi regarding the time it takes for preparation of these reports, so that that can guide us in determining the return date.
It will depend where the victims, their geographical area, and this person's geographical area. So, like, for my bit, it will take maybe a month.
Okay. All right. Okay, everything considered, considering the submissions that have been made by the Landed Council on record, the application made by Ms. Kikui for the state, and the responses by the Landed Council. I will take that into account when giving the directions that I'm about to give. And the directions are as follows. The case is adjourned with the following orders: that pre-sentence reports shall be filed by the probation department within the next 21 days. Victim assessment report to be filed within the same period of time. The reports, once filed, shall be shared with all the parties. We can get a date after the 21 days when the matter can be mentioned to confirm that those directions have been complied with. And pending that mentioned date, the accused persons shall be remanded in custody as their bonds have been cancelled.
Your Ladyship, are we going to have a mention and then we fix a date for the sentencing? Or we're going to fix a date for the sentencing?
I was thinking that we can take a date for the mention first so that we confirm that the documents are filed, so that we can now take a date for the sentencing hearing knowing that we have the documents are ready, so that we don't take a date for sentencing and then it does not take off for lack of the filings. And the reason I gave 21 days is because I thought we could expedite them without having to give the period that was estimated, that the time that they usually take is more than 30 days. Yes.
So, Your Ladyship, can we mention, subject to your diary, on the 17th of August? I suspect that may be vacation time, and we may need your guidance as to which date you are available. You could probably make the mention virtually. To make things easy for you.
I think that's reasonable.
Do we take then the 17th? Virtual mention?
It's okay. Is it convenient to all?
It is convenient.
Mhm.
It's only that Jack says, will the judge remember the date?
My lady, I'm saying it will be a Monday. And
Is it a Monday?
Yes, it's
I've
a Monday.
had a few issues with Monday. You know that.
We can make it 18.
You can have the
That's a
Tuesday.
If that's comfortable for the court. But you could give us time indication.
I think 11 is a good time.
Yes.
So at least, my lady, on Monday you can remind Mr. Kino to remind the court.
No, it's okay. I'll remember. It will be recess time. I will not be working in a different station with a huge cost list. But we have taken the 18th.
Yes, so we've taken Tuesday the 18th at 11 o'clock virtually.
Okay. Okay. So those are the orders and directions issued by the court. And the accused persons are hereby formally informed that they have a right of appeal to the Court of Appeal.
My lady, you did not talk about my request for the judgment. I do not know if you have it.
Okay. The judgment is here with me, is typed, but of course I will need to proofread it just to correct a few typos here and there and to polish it up a bit. So I will require your indulgence because it's a very long judgment, as you must have noted. So it will take me a bit of time to finish with the proofreading. But probably by early next week, it should be published. And I will also make an order that you be provided, and as a general order that any of the councils be provided with a typed copy, but of course upon payment of the requisite fee.
Even uploading it to the CTS will be there.
Okay.
Do we take time, specific time for the mention?
Yes, I thought we said 11. We've agreed on 11 a.m. So if there is nothing else, then I think it's a good time to adjourn.